Hello everyone, welcome to this video session of Legal Aptitude. Let's begin. First, let us read the instructions. It's very important for you to read these instructions very carefully. Let's read the instructions, and these instructions are going to be applicable for all the questions that I'm going to do further, which are based on principle and fact. Let's read them. The legal aptitude section of legal proposition, which is referred to as principle and facts. Such principles may or may not be true in the real legal sense. This is very important. Whatever has been given to you, you have to presume that that is true. Yet, you have to conclusively assume them to be true for the purpose of this section. In other words, in answering the following question, further you must not assume any other fact than those which are given in the question. Facts only those which are given in the question, and the legal proposition you have to presume that it is true. What is the objective of this section? What is the objective of this legal aptitude section in your entrance exams? The objective of this section is to test your interest towards the study of law, research aptitude and problem solving ability, how logically and how well in a coherent way you can think. Even if the most reasonable conclusion at which you have arrived, it seems absurd to you or unacceptable for any other reason. To answer a question, the given principle is to be applied to the given facts, and then you have to come to the most reasonable conclusion. This is what you have to do. Now let's go with the first question, and then you will be able to understand better. See what is given in the first question. The first question very clearly, first you are given a principle. You have to read each and every word of the principle extremely carefully. You have to read it very carefully and see what does it say here. It says the concept of natural justice is against bias. And what is exactly bias? Bias is when a person acts in an unfair way. Okay, so the concept of natural justice is against bias. Bias means giving preference to someone or somebody and not being fair. Concept of natural justice is against bias and for the right to a fair hearing. Okay, it says while the term natural justice is often retained as a general concept, it has largely been replaced and extended by the general duty to act fairly. What is meant by duty to act fairly? That means that a person should be given an impartial hearing. Okay, he should be given a full opportunity to present his side of the case. Justice should not only be done, it should even seem to the other person that it has actually been done. So this is your principle. Now facts have been given after that, and what are the facts? The fact says that X is a male employee of a company and he was dismissed by the employer, that is the person who gave him the job, just on the basis of a complaint made by Y. So X is a male employee, Y is a female employee. Fine. Y is a female employee. This female employee, she has made a complaint against this person X, a female employee of the company. And what is the complaint? The complaint is that X was trying to be too friendly with her and often requested her to accompany him to the canteen. And then what happens? The employer very clearly, what does he do? The employer removes X from job. Okay, is the dismissal of X valid? Now you have to decide whether the dismissal was valid or not. Okay, and after that what has been done? You have been given these four options. Firstly, no, because in modern times this type of behavior is common. No, this cannot be the answer. This is just a presumption that in modern times this kind of behavior is common. Second one, you see read very carefully. Do you think in this particular case justice has been done? Do you think the employer has fulfilled his duty to act fairly? Do you think that he has acted in an unbiased way? Now when you go through all four options, you will realize that the second one, because the employer did not give a chance to X to explain his side, thereby violated the principles of natural justice. Yes, in the principles of natural justice, what is there? There is general duty to act fairly. He has not done that. Very clearly it is given that he was dismissed just on the basis of a complaint by Y, solely on the basis of that complaint he was dismissed. So B is going to be my right answer. He has violated, the employer has violated the principles of natural justice. Yes, moral law is antique and therefore nothing has been mentioned about moral law in this situation. So this cannot be the answer. Yes, because men are not supposed to behave improperly with women. Hence there is no violation of any principle of law. There has been a violation of duty to act fairly. So here in this one, what will be my answer? Answer here is going to be B. Okay, let's move on to the next one. Okay, here what does it say? It says ownership in property consists of right to possess. Who is known as the owner of somebody? Owner is going to be the person who owns that particular thing. I am the owner of this pen, this pencil, this property, this house, etc. That person is known as the owner. And what rights does the owner have? Ownership in property consists of right to possess. Okay, that thing is going to belong to him. Right to use it, he should be able to use it. If you have a car, you should possess it, you should be able to use it. And right to alienate. What do we mean by alienate? By alienating we mean we can transfer the ownership to another person or group. That is alienating. Okay, so if I have a car, I have the right to alienate it. I can transfer the ownership to my daughter, to my sister, to my nephew, etc. And even the right to exclude others. So see, in the first part of the principle, what exactly is ownership? That is defined here. It is the right to possess something, it is the right to use something, it is the right to alienate, and it is also the right to exclude other people from using it. If I have a car, I can tell Mr. XYZ that you are not supposed to use my car. That is under the right to ownership. And when is sale complete? Sale is complete when property gets transferred from the seller to the buyer on sale. When is sale complete? Sale is going to be complete. What happens in a sale? I am going to make a payment, okay, or I am going to promise to do something, and the other person is going to give me that thing what I want to buy. If it's a dress, I'll make a payment and he'll give it to me. Only when it is delivered to the buyer. Sale is complete when property gets transferred from the seller to the buyer on sale. This is your principle, okay? Now, based on these principles, you have a fact. What do the facts say? A sold his car to B. There are two people here. One is A and one is B. Okay. What does A do? A sells his car. Okay. And he sells it to B. B is the person who buys it. Then what does A do? He has sold it. Then A sold his car to B. After this, B has made a request to A to keep the car in his care on behalf of B for 1 month. Maybe there were certain circumstances due to which he could not take an immediate delivery, and he tells him, you keep the car with you for 1 month, and A has agreed to do this. A says, fine, you can collect it after 1 month. Now here, sale of car is not complete. Sale of car is not complete. This is incorrect, because see, ownership means what? Ownership also means the right to alienate. That means you can give it to somebody, you can transfer the ownership to another person or group. That is given here very clearly. Okay. Now when B becomes the owner, he is requesting A to keep it with him. Now here, sale will be completed when B will take the delivery of the car. No, sale is already complete. Sale is already complete, and after the sale has been completed, this person B is requesting A to keep it for 1 month. So sale, here we have sale of car is complete and sale will be automatically completed after the expiry of 1 month. No. Here what is going to be my answer for question number 2? Answer will be C. Sale of car is complete. There is no question that it has not been completed. Okay. So what is the answer here? Answer here is going to be C. C is the right answer. Next one, third one. I hope you are being able to understand and think logically. Here it says every agreement by which any party is restricted absolutely. Okay, there are two terms. One is absolutely. Absolutely means completely, and the other is partially. Partially means only up to a certain level. So every agreement by which any party is restricted absolutely from enforcing his right in respect of any contract by the usual legal proceedings in the ordinary tribunals is void to that extent. Okay. The law also provides that nobody can confer jurisdiction to a civil court by an agreement between parties. What do you need to understand here? See, suppose you and I are making a contract, and in that contract there is a clause that none of us can approach the court. Okay, there is absolute restriction. There is absolute restriction that suppose something goes wrong and we can, it says even if anything goes wrong, we cannot approach the court. Then that part, okay, it says every agreement by which any party is restricted, they are not restricted and restricted absolutely. You are completely restricted from enforcing the rights in respect of any contract by the usual legal proceedings in the ordinary tribunals. Then that part of the contract is supposed to be void. It will not be applicable. Okay. The law also provides that nobody can confer jurisdiction to a civil court by an agreement between parties. This has been given to you. Now, what are the facts? Facts are A and B entered into a valid contract. A and B are two parties. They have entered into a contract for rendering certain service. There is a contract. A clause in the contract was that in case of any dispute arose out of the contract, it shall be referred to arbitration only. If there is a dispute, they are going to refer it to arbitration. And what do I mean by arbitration? See, arbitration is a method by which we settle disputes. Okay, there is going to be a person appointed who it would be a person, it could be an independent person, and this independent person is known as an arbitrator, and he is going to settle the dispute. Okay, now here what is there in their contract? The contract very clearly says there is a clause in the contract was that if there is a dispute in the contract, it will be referred to arbitration only. There is going to be arbitration only. Now, is the contract valid? Now let us see. See, first point had said that there is absolute restriction, there is complete restriction from enforcing the right. But in the second case, is there complete restriction? No, there is not complete restriction. The clause says that there is going to be arbitration. Arbitration is going to be the method by which they are going to settle the dispute. Now let's try to do it. Okay. Yes, now let us see. Arbitration is also a valid dispute settlement machinery recognized by law, hence the entire contract is valid. Absolutely right. My answer is A. The parties were trying to confer jurisdiction to some authority to decide a dispute, hence the clause would be invalid. No, this is not going to be the answer. Now next one, the arbitrator cannot be termed as an ordinary tribunal, hence the agreement is void. No, this is also incorrect. Contract is valid, but the clause regarding arbitration is void. No, this is also incorrect. Okay, it had said in the principle that there cannot be absolute restriction, and here there is no absolute restriction. They have just said that if there is a dispute, then there is going to be arbitration. Fine. So correct, question number 3, my answer is A. Let's move on to my fourth question, and what has been given in the fourth question? Fourth question says, in a case of fraud, where a party to a contract knows or believes a fact to be true, but conceals it actively. Okay, what do you mean by conceal? Conceal means hide. Okay, but hides it actively. Actively means that that person has made an effort to hide it. Okay, from the other party with a view to induce that person to enter into the contract. Okay, it says, suppose there are two people, one is A and one is B. Okay, now it is going to be a fraud. If A knows there is a fact which he should disclose, okay, which he should disclose, which he knows it is going to be true, and it is going to affect the contract if he discloses it, but he makes an effort to hide it, then in such a situation it is going to become a fraud. It is a case of fraud where a party to a contract knows or believes a fact to be true but hides it actively from the other party. And why are they hiding it? He is hiding it, with a view to induce that person to enter into a contract. Okay, so that this person B enters into a contract with him. That's why he is hiding it. Okay, this has been given to you. Now here, while taking a life insurance policy, in reply to questions by the insurance company during the inquiry into his proposal, Zamir deliberately means intentionally, concealed the fact of his medical treatment for a serious ailment which he had undergone only a few weeks ago. Now what is the situation here? Let me explain the situation to you first. There is a gentleman, okay, if I can call him a gentleman, and the gentleman's name is Zamir. Okay, his name is Zamir. He is taking an insurance policy. There's going to be an agreement now between Zamir and the insurance company. There's going to be a contract, right? Now, Zamir is undergoing a medical treatment. He is undergoing a medical treatment for a serious ailment. Only just few weeks ago, he had undergone this treatment, and when the insurance company makes an inquiry about his health conditions in the proposal, he concealed this fact that he had undergone the treatment. Why is he concealing it? So that he can enter into the agreement. Right? So, now is this fraud? According to the given principle, yes, it is a case of fraud. Why has he hidden this? He has hidden this because he wants to induce, he wants that the insurance company should enter into a contract with him. Now, let us see the options. Now, here, the first option says, the act of Zamir did not amount to fraud. This is incorrect. It amounted to fraud. Very clearly, what is fraud has been defined in the principle. The act of Zamir amounted to innocent misrepresentation. No, it is not innocent misrepresentation because he has deliberately means intentionally concealed the fact. He has intentionally, innocent misrepresentation is there when something happens accidentally. So this cannot be the answer. The act of Zamir did not amount to any misrepresentation. This is incorrect. Concealment of fact by Zamir amounted to fraud. Absolutely right. Question number 4, my answer here is going to be D. Question number 4, answer here will be D. That's the right answer. Read each and every part of the principle and then try to apply it to the facts. You are going to be in a very comfortable situation. Now, let's move on to the next one. Now, here it says, contract is a written or spoken agreement. What exactly is a contract? A contract is a written or spoken agreement with specific terms. There are specific terms to it between two or more persons or entities in which there is a promise to do something in return for a valuable benefit known as consideration. Okay, what is going to happen in a contract? I am going to, like for example, if I am selling something, okay, I am going to promise to deliver it, and what are you going to do? You are going to give me money in return. Now, this is a contract. A contract can be written, it can be spoken. It's a written, there can be written and spoken contracts. Verbally also there can be contracts with specific terms. There are specific terms and conditions in the contract between two or more persons or entities in which there is a promise to do something in return for a valuable benefit, which in most cases is money, and that is known as consideration. Such an agreement is intended to be enforceable by law. All such contracts, if one person backs out, that they can be enforced by law. You can approach the court and you can seek the remedy. A unilateral contract is one in which there is a promise to pay or give other consideration in return for actual performance. Now here I need to explain to you what exactly is a unilateral contract according to what has been given here. See, unilateral contract is one where a contract is created by an offer that can only be accepted by performing it. Okay, you do not have to communicate to the person that I have accepted your contract. Like for example, if my nephew has got lost, when I place an ad in the newspaper under the lost and found section and I say my nephew has been lost and anybody who finds him and brings him back to the house will get an award of 5 lakh rupees. Then in such a situation, anybody who finds my nephew, now is he actually performing? Yes, he is looking for that person, he is finding him and he is bringing him back to me. That is a unilateral contract. Okay, that was an example. So a unilateral contract is one in which there is a promise to pay or give consideration in return for actual performance. Okay, all these contests, rewards, etc., where the rewards are given, these are all examples of unilateral contracts. Okay, now let's do it. Now we have the facts here. A toilet soap manufacturing company is there in India. In order to promote the sale of their product, they gave an advertisement in all newspapers on January 1st, 2017. This is the date on which they give their advertisement, that the company has kept a model ignition key of an Audi A3 car. The advertisement also stated that whoever gets the said key before December 31st, 2017 from a soap bar will be gifted with the Audi A3 car. So this toilet soap manufacturing company says that in one of their soaps they are going any buyer, they are going to find a key, and if they can, anybody who finds that key, they bring the key to them before 31st December 2017 from a soap bar, such a person will be gifted an Audi A3 car. This is the unilateral contract, okay? Mr. Martin, who was a foreigner, he came to India as a tourist who was staying in a hotel, found a key similar to the same car ignition key, and Mr. Martin brought this matter to the notice of the hotel manager. The manager informed Mr. Martin about the company's advertisement which was given on 1st of January 2017. Mr. Martin wants to claim the car. Will Mr. Martin succeed? Okay, I hope you got the facts very clear. Now let's take a look. First one, it says no, he will not succeed. Okay, he says no, he will not succeed. The soap company has not entered into a contract with Mr. Martin as he was not in India on 1st January 2017. Nowhere has it been said that the person should be in India, whether he should be a foreigner, whether he should be an Indian. The facts, it very clearly says that it has very clearly said that it's a unilateral contract is one in which there is a promise to give a consideration. So nothing has been mentioned about that. So first one is incorrect. Second one is no. Actual intention of the company was to promote the sale of the soap. No, the company has very clearly mentioned in their advertisement that anybody who finds the key, they are going to be gifted with the Audi. So it is not correct. Second one is also incorrect. Hotel manager who could legally claim the car as he was the one actually purchased the soap for the use in the hotel. No, it has not been mentioned here. It very clearly says advertisement stated that whoever gets the said key, the person who gets the key, it is not mentioned about who will purchase it, who will use it, all that is not mentioned here. Mr. Martin obtained the key before the stipulated date from the soap bar. Yes, because they have very clearly mentioned December 31st, 2017. Okay. And Mr. Martin, who was staying here, he got it before the date. Mr. Martin obtained the key before the stipulated date from the soap bar. So he is covered by the offer of the soap company and he can claim the car. Absolutely right. Answer here is going to be D. Answer here is going to be D. So that was the last question to be done in this video. I wish you all the best. Thank you so much for watching. Bye bye.